we can see Criminal Procedure Code. Today, bail, chapter 33. இந்த வகுப்பில் குற்றவியல் நடைமுறை சட்டத்தில் பிணை பெயில் அத்தியாயம் 33 பார்க்க போகிறோம். ஸோ பெயில், வாட் இஸ் மீன் பை பெயில்? பிணை என்றால் என்ன? ஸோ a person has to appear before the court for certain proceedings. For example, he has committed an offense. So a person required to attend before the court, so he has to appear whenever court ordered to appear. His presence is required. So under such circumstance, he will be released by the court with a condition: he should appear before the court whenever an order is made to that effect. The releasing order is granted by the court with or without sureties. It is a discretion of the court. That is called bail. பிணை என்றால் என்ன? ஒருவர் ஒரு நீதிமன்றத்தில் அவர் ஆஜராகி வேண்டிய ஒரு சூழ்நிலை இருக்கும். அவ்வாறு அவர் ஆஜராக வேண்டும் என்பது நீதிமன்றத்திற்கு தேவை இருக்கும் பட்சத்தில் நீதிமன்றம் அவரை வேண்டும் பொழுது, உத்தரவிடும் பொழுது, எப்பொழுது ஆஜராக வேண்டும் என்று உத்தரவிடுகிறதோ அப்பொழுதெல்லாம் நான் ஆஜராக தயாராக இருக்கிறேன் என்பதை நீதிமன்றத்திற்கு ஒரு உறுதிமொழி கொடுத்து அவரை நீதிமன்றம் விடுவித்தால் அதற்கு பிணை. அதற்கு அந்த பிணையில் விடுவதற்கு ஜாமீன்தார் உடன் நிபந்தனை, ஜாமீன்தார் உடன் உத்தரவிடலாம் அல்லது ஜாமீன்தார் இல்லாமலும் உத்தரவிடலாம். ஓன் பாண்ட், தட் இஸ் கால், சொந்த ஜாமீனில் அல்லது வித் சூரிட்டிஸ். ஸோ செல்ஃப் ஓன் பாண்ட், சொந்த ஜாமீன், ஆர் வித் சூரிட்டிஸ், ஜாமீன்தார்களுடன் விட வேண்டும். ஸோ தட் இஸ் தி பேசிக் திங்ஸ். ஸோ what are the circumstances a bail can be obtained? What are the circumstances a bail can be denied? So these are the fundamentals. So the bail is nothing but release of a person by the court to appear him before the court whenever the courts ordered to appear before him. The releasing order with sureties or without sureties, and but is on his own bond, and it depends upon the discretion of the court. That is called bail. So bail is nothing but release of a person. His presence is required by the court in future, and in future he is bound to appear whenever court ordered to appear him in future. The releasing order is nothing but with sureties or without sureties. On his own bond he can be released. That is called bail. So now we are going to see the provisions of bail and bonds. Bond is nothing but the undertaking, model forms upon which he has to execute the court. Bail bond, பிணை பத்திரம். So bail bond is nothing but what is the undertaking is given by him with sureties or without sureties. He has to appear before the court whenever the court ordered to appear him before the court. That is the, you can read the bail bond, you can, meaning of it is one and the same. That is the bail bond. So whether the bail can be granted under what circumstances we are going to see one by one. That is the bail and bail bonds. So 436 in what cases bail to be taken. So, in certain cases, as per the Schedule 1 of the CRPC, as per the Schedule 1 of the CRPC, certain offences are classified as bailable. So, that is the depends upon the gravity of the nature of the offence. the granting of bail is given. So, you can go through the Schedule 1 of the CRPC. So, the minimum, the gravity is more, then it will be converted as a non-bailable. If gravity is lesser, it is treated as a bailable one. So, it depends upon the gravity, and the discretion of granting bail is fixed by the CRPC. That is the basic things. So, what is meant by bailable? So, it is classified in the Schedule 1 or offences which is less than 3 years of punishment is classified as bailable offence. So, a person committed an offence which is bailable. So, a person committed any offences or offence, they are all bailable if he is arrested. If he is arrested, then he can present the bail before the court, and immediately, without any discretion, court is bound to grant him bail with or without sureties. That is the matter of right. So, in bailable offence, once application is filed before any court, the court is bound to grant bail. That is the bailable offence. ஸோ ஒரு பிணை என்பது என்றால் என்ன? நீங்கள் குற்றவியல் நடைமுறை சட்டத்தில் பிணையில் விடத்தக்க குற்றங்கள் என்று வரையறை செய்யப்பட்டுள்ளது. பிணையில் விடத்தக்க குற்றங்கள் என்பதை பார்த்தீங்கன்னா, அந்த குற்றத்தின் தன்மையை பொறுத்து குற்றம் கொடூரமாக அது பிணையில் விடக்கூடாத குற்றமாக அறிவிக்கப்பட்டுள்ளது. ஷெட்யூல் அட்டவணை 1. அதனுடைய தன்மை குறைய அது பிணையில் விடத்தக்க குற்றம் என்று, அந்த சீரியஸ்னஸ், அதனுடைய தன்மை ரொம்ப கொடூரமாக இருக்கும் பட்சத்தில், ரொம்ப கொடூரம் அவைகளை கொலை செய்தால் அது பிணையில் விடத்தகாத குற்றம். லேசாக ஒரு கன்னத்தில் அறைந்தால் 323, அது 324. குச்சியில் அடித்தால் அது சிறு காயத்தை ஏற்படுத்தினால், டெட்லி வெப்பன், ஸோ கத்தி போன்ற ஆயுதங்களை பயன்படுத்தி சிறிய காயங்களை ஏற்படுத்தினால் அது பிணையில் விடத்தக்க குற்றம் என்று அழைக்கப்படுகிறது. ஸோ whenever it is classified as a bail, he is arrested by the police during the time of investigation. Then he is brought before the court to remand him to judicial custody. So you are entitled to file a bail application before the court, and you can file the bail application. It is a matter of right. Once it is presented before the court, no other option except granting the bail. That is the basic things of the 436. ஸோ 436 ஒரு பிணையில் விடக்கூடிய குற்றத்தை ஒருவர் புரிந்த பின்பு சம்பந்தப்பட்ட புலனாய்வு அதிகாரி அவரை கைது செய்து நீதிமன்றத்தில் ஆஜர்படுத்தினால், அவ்வாறு ஆஜர்படுத்தும் பொழுது அவருக்கு பிணை வழங்க வேண்டும் என்று பிணை மனு 436, you have to file a petition under 436. You have to mention the provision, then only it can be come to the court that it is a bailable. If you are presenting 437, then it is treated as a non-bailable. So, what is the offence committed by the accused at the time of remanding? You have to go through whether all the offences are bailable or non-bailable. You have to seek. Then only you can present the bail application. So you must go through what are the offences are committed by the accused as per the FIR. Then he is brought before the court for remanding to the judicial custody. So you can see all the offences are bailable. You have to file a bail application under 436. That is the basic things. Then after finding the bail is granted without surety, you have to present the sureties and the court will release him on bail. That is arrest is made. Then there is an FIR is registered against you. முதல் தகவல் அறிக்கை உங்கள் மீது பதியப்பட்டுள்ளது. உங்கள் மீது வழக்கு பதியப்பட்டுள்ளது. You, the accused himself voluntarily appear or produced by the counsel. Then you have to surrender the accused before the court with the surrender petition and along with the bail application. So whenever an FIR is registered, police is not arrested the accused. If you want to get the bail in such a case, you have to surrender him by filing a surrender petition, and along with it you have to file a bail application under 436 if it is a bailable one. Then surrender will be accepted, he will be remanded immediately. The bail application will be granted with the sureties. That is the 436. So you have to, what is 436? I will read. Where any person other than a person accused of non-bailable is arrested or detained without warrant by an officer in charge of the police station. So police station irundhalum, so a person is arrested, ஒரு நபர் non-bailable இல்லாத குற்றங்களுக்காக கைது செய்யப்பட்டு காவலில் வைக்கப்பட்டால் அல்லது is brought before the court by warrant by an officer and appears is or brought before the court. Appears he himself surrender, that is called surrendering, or brought before the court. Police him itself brought him to the court for the purpose of putting him into judicial custody. So that is the basic things. Whenever a person, an FIR is registered, the police arrest him and brought him to the court. If the offences are relating to that particular case is bailable, you are entitled to file a bail application. At the time are prepared, is prepared at any time, even at the time of remanding itself you are entitled to, or at any other day. So you are ready to give any other day. If he is remanded, the parties are coming to you, approach you, then after 2 days or 3 days you want to file you are ready to, you are prepared at any time in custody of such a person, at any stage of the proceeding, the court to give bail such a person released on bail. So as soon as presenting the bail application, the court to give the bail such a person is released on bail. That is the base. He is ready to give undertaking to appear whenever as remanded by the court. That is called bail. I am ready to appear. Kindly release me on bail. So your prayer is like that. என்னை பிணையில் விடுங்கள், நான் நீதிமன்றம் எப்பொழுது ஆஜராக சொல்லி உத்தரவிடுகிறது அப்போது ஆஜராக தயாராக இருக்கிறேன் என்று ஒரு மனு தாக்கல் செய்தால் அந்த மனுவின் அடிப்படையில் நீதிமன்றம் உடனே அவருக்கு பிணை வழங்குது. So the court will grant bail immediately, provided such officer or he thinks may pay that may, instead of taking from such a person, discharge him executive bond without warranty hereinafter provided. So the police officer himself, if it is a bailable offence, he is ready to give sureties or bail to the officer who arrested the accused. Then the officer in charge of the police can release him on bail. So session jamin. So the session itself you are entitled to get the bail. You are presenting an application I am ready to give bail to the investigation officer. You send a petition and you are giving a petition, then the investigation officer himself can grant him bail without sureties. That is the basic things. So, the court also release a person on bail in case of bailable offense, and also the police officer himself can release him on bail if it is a bailable offense. That is the power granted to court and the investigation officer to grant bail in case of bailable offenses. That is the 436 explanation. Where any person unable to give bail within a week shall be sufficient for officer to presume that he is indigent person proviso. So he is unable to give bail within a week from the date of arrest. ஒருத்தனுக்கு வசதியே இல்லை, so he is not affordable to spend money. Within a week he is arrested and remanded to judicial custody. He is not able to affordable to get the bail. It is shall be sufficient for the officer or court presuming he is indigent person for the purpose of this. So, our variable, so indigent vasadi illadhavar, so he is not affordable to get the bail. Then nothing is deemed to 446 of the CRPC. That is the basic things. Then 436 subclass 2. So subclass 1 granting bail. So whenever, even though it is a bailable offense, whether the court is entitled to dismiss the bail application. That is the 436 subclass 2. So 436 துணைப்பிரிவு 2இல் ஒரு நீதிமன்றம் பிணையில் விடக்கூட குற்றமாக இருந்தாலும் அந்த பிணை மனுவினை தள்ளுபடி செய்யலாம். When court is entitled to dismiss the bail application relating to the bailable offences, that is the notwithstanding any kind where any person has failed to comply the condition of bail bond regards the time and place of attendance. So jumped bail, that is called, already he was granted bail. He is not obeying the condition of the bail, and again he is arrested by the police by issuing warrant by the court. So he is produced, already he is released on bail. He is not obeying the bail bond condition. He is not appearing. Then the warrant is issued and he is brought before the court. Under such circumstance, he is not obeying the bail bond condition. He is not obeying the order of this court. Hence, the application is dismissed. That is, the already on bail person is not obeying. He fails to appear before the court. Subsequently, warrant is issued and he is brought before the court. Then the court can dismiss the bail application, even though it is a bailable offense. That is the. So the court may refuse to release him on bail when on subsequent occasion on the same case appears or brought to the custody shall refuse without prejudice the power of the to call any person shall bound by to pay the penalty thereof under 446. And whenever he appears before the court, 446, he is bound to take action against that person. He is bound to pay that amount what is mentioned in the bond. Suppose a court ordered to him release, he should execute the bond rupees for 1,000 rupees. He fails to appear, and the court can pass an order to pay up to 1,000 rupees to release him on bail. So already a bail granted person failed to appear, failed to comply the condition, subsequently appear, the bail bond amount what is executed can be imposed upon him, and thereupon the court is entitled to impose such an amount. That is the basic things. Then It is enactment on the part of the magistrate to consider the 342 of IPC non-bailable, merely looking in the printed book. Under the amendment 2005, 325 and fifth column, the word bailable deleted, the word non-bailable included. The amendment of CRPC and was followed by notification on 21/6/2000. However, notification shows that 43 of amendment has been not come into force. That such a remains on 324 remains bailable. The above way, the offence alleged petitioner may be bailable on in petitioner for anticipate bail is dismissed. So, whether in a case of bailable offence, you can seek an anticipate bail. பெயிலபிள் அஃபென்ஸுக்கு பிணையில் விடக்கூடிய கூட்டத்திற்கு முன்ஜாமீன் பெற வேண்டும் என்றால் போட முடியாது. You can surrender before the court, concerned court, and you can get the bail. There is no need to get anticipatory bail. If it is a bailable offence, anticipatory bail application will not lie. That is the 438. All the offences are bailable. You are entitled to get bail before the concerned court, upon which the case is pending. எந்த கோர்ட்டில் வழக்கு நிலுவையில் இருக்கோ அந்த கோர்ட்டுக்கே நீங்கள் நீதிமன்றத்தை அணுகி உடனடியாக பிணை மனு தாக்கல் செய்து நீங்கள் பிணையை பெற்றுக்கொள்ளலாம். தட் இஸ் தி பேசிக் திங்ஸ். ஸோ 436 subsection A, maximum period for which an under trial prisoner can be detained. So if it is a bailable offence, bail is granted, but no sureties is produced, then he is undergoing trial, or he is not filing any bail application, but he is remanded to custody, he is undergoing trial. So what is the maximum period he can be kept as under trial prisoner in a bailable offence? ஸோ ஒரு பிணையில் விடக்கூடிய கட்டத்தில் வழக்கில் வழக்கு கோப்புக்கு எடுக்கப்பட்டு வழக்கு விசாரணை சாட்சியல் விசாரணைக்கு போடப்பட்ட நிலையில் எவ்வளவு நாட்களுக்கு அவரை அந்த வழக்கில் கஸ்டடியில் வைக்கலாம், நீதிமன்ற காவலில் வைக்கலாம். How long a person can be detained in judicial custody in case of bailable offence? Trial begins even though he did not release on bail. That is the base thing. When a person has, during the period of investigation or inquiry or trial under this code, offences law not being offense with death or in suspended and detained, undergone detention for extending up one half of the period of imprisonment specified for the other, that one half of the, for suppose 1 year 3 months he can be kept in the judicial custody for 3 months. He shall be released on bail on personal bond without sureties. So an offence is committed, the punishment for is 1 year, and a trial 3 months over, then he should be released immediately after the expiry of 3 months in the judicial custody. He should be released on bail. That is the 436A. In order to safeguard the liberty of each and every citizen, the court ordered to amend the CRPC. So a person for a non-bailable petty offences, he will be kept for years together. In order to safeguard his liberty, in case of bailable, so he can be kept for some time alone. That is the own bond. Provided that after hearing the public reason to be recorded in right containing such a period longer than the one half of the sentence period, and instead of without sureties. So பாதிக்கு மேல், so one half of the 1/4 of the sentence already is undergone, he will be released. No such person will be detained during the period of investigation of more than maximum period provided for the said offence under that law. So if a person is arrested, the punishment for that case is only 1 year, but the trial could not be completed within 1 year. Then he can be kept up to maximum period 1 year alone, not more than that. ஒரு வருடம் தண்டனை இருக்கிற வழக்கில் பிணைகளோட வழக்கமாக இருந்து அந்த வழக்கு சாட்சியை விசாரணை செய்யாத மேக்ஸிமம் பீரியட் எவ்வளோ வைக்கணும்னா அந்த அஃபென்ஸுக்கு எவ்வளோ 1 இயர்னால் அதுக்கு மேலே வைக்கவே கூடாது அப்படிங்கிறேன். ஸோ தண்டனை கொடுத்தாலே 1 இயர் தான் கொடுக்க முடியும். ஸோ தட் இஸ் தி மேக்ஸிமம் பீரியட். ஸோ 436 is deals with the bailable offense. So general bail, you can see that is the basic things. So this is only, it is a matter of right, it is a constitutional right. Getting bail is a constitutional right under 436. The liberty of citizen is guaranteed under the Constitution. If a person commits a bailable offense, it is a matter of right, he is entitled to bail. That is the basic things of the object behind the 436. ஸோ அதை ஒரு மனிதனின் சுதந்திரம் என்பது இந்திய அரசியலமைப்பு சட்டத்தின் கீழ் பாதுகாக்கப்பட்டது. ஒருவர் பிணையில் விடக்கூடிய குற்றத்தை செய்தால் அவருக்கு உடனடியாக பிணையில் வழங்க வேண்டும் என்ற காரணத்தின் அடிப்படையில் தான் பிரிவு 436 குற்றவியல் நடைமுறை சட்டம் இயற்றப்பட்டுள்ளது. That is the basic. With this I conclude my class. We will see in the next class. Thank you. If you are not subscribing my channel, kindly subscribe by clicking the word subscribe. Thank you for doing the same.